Good morning. This is Jason Hutt from Bracewell. Thank you for joining us again this month. This is the monthly series that we hold via webinar for in-house counsel. It's a 30-minute presentation. The topic selected for this month is engaging environmental specialists and preserving the privileges associated with that. We selected this topic based on a bunch of feedback that we got from our seminar back in early November. This was a popular topic amongst the in-house counsel, and a bunch of questions were asked. I suspect that we'll cover something like this and related topics at our spring seminar, which will be hosted again in our Houston office. But recent topics have also included environmental audits, waters of the United States, the new approaches to NEPA. We did a webinar on the intersection of bankruptcy and environmental law, as well as some insights from the Trump administration's unified agenda and a suspension and debarment topic. You can find those presentations and this presentation once it concludes on the Bracewell website on the Insights tab from our practice page, if that's helpful to you, or follow up with either myself or my colleague, Kevin Collins, who's my partner in Austin and joins me today. Kevin and I are doing this presentation really because I handle a bunch of enforcement defense matters as well as transactions on behalf of the Environment and Natural Resource section, where the issues of privilege and work product doctrine come up frequently. And Kevin brings the perspective of a former federal prosecutor in the from the Eastern District of Texas, and in private practice for a number of years, he has led our efforts on incident investigations and enforcement in both the civil and criminal context, where these issues also manifest themselves. So I hope our perspective is helpful. We'll flip through the slides pretty quickly here. If you do have questions as we go along, please type them into the comment box on your screen. We'll get to as many of those as we can at the end of the webinar. And if we run out of time, we're happy to respond to questions via follow-up email, or you can find our contact information both on the last slide of the presentation as well as our webpage. So with that, I'll kick things off, flipping to the first sort of substantive slide of the presentation. As probably most on the phone know, there are basically two withholding doctrines. Both of them are judicial in nature. The first, the attorney-client privilege, protects confidential communications between an attorney and their client made for purposes of seeking or rendering legal advice. And the second, as most of you are probably familiar with, the work product doctrine, which seeks to protect tangible documents and communications that basically are based upon the impressions that are formed by an attorney. This is really to set the stage for the discussion coming after this, but keep in mind that each of these doctrines are judicially created. They do not apply in the context of congressional investigations. I think that's something that we always want to keep in mind from a perspective standpoint, but also because as we shift into a Congress that is where the majority in the House of Representatives is a Democratic majority, we may see Congress flexing more of its muscles on the congressional investigation front. And so bearing in mind the absence of these protections in the context of congressional investigations is an important one. So we briefly outline the key questions related to each of those doctrines. Obviously, under attorney-client privilege, who is the client, who is the attorney, and was the communication for legal advice? We'll touch a little later in the presentation on sometimes the sort of the line that we straddle as lawyers, and particularly as in-house counsel, on whether or not we're providing business advice or legal advice. And so that question can come up if attorney-client privilege is challenged. And the work product doctrine really has a number of different questions that the courts have sort of laid out for us in different decisions, and we'll touch on a couple of those. But was the document created because of or in anticipation of litigation, and did it contain any of these different things: mental impressions, conclusions, opinions, legal theories, attorney notes? Always bearing in mind that, for example, in witness interviews, which is something that Kevin finds himself doing pretty frequently, you know, if you're simply recording or making a record of what the other party says, that is not a mental impression, conclusion, or an attorney note. And so we always have to be careful about how we summarize a meeting with someone if we expect to assert a work product doctrine protections associated with it.
Yeah, Jason, I have a practical suggestion here with respect to memorializing internal investigation notes. here's a couple of things you can write down as takeaways. Number one, you should have something at the beginning, an initial paragraph of if you're going to memorialize a note that explains that this is not a verbatim transcript of the dialogue that you had with the witness. The other thing you can do at the beginning, and this is a way to cut down on legal costs, is if you have time and remember at the beginning of an internal investigation, particularly one that may be high profile, make a decision about what you may do with these notes. Are you going to seek maximum protection and put up the work product doctrine shield and to prevent the government or to prevent others from getting to these documents? If you are, then you want memoranda that are based in prose that include a lot of attorney conclusions and connections and mental impressions hardwired into those notes. If you don't feel like you're going to do that and you want to keep your legal costs or legal spend down, you can go with notes that are more bullet based and really just gathering key facts and then maybe a section at the end that sort of has some connections. But if you go to the mattresses and you're in chambers with a magistrate judge or a district judge trying to explain why these are protected, the way you develop those notes makes a huge difference in those arguments. All right, so we're going to move from that basic big picture outline, and we're going to talk about how you can extend the privilege. And the way I like to think about it, it's sort of a thumbnail sketch, but it works. Is in one way you're extending the privilege because you're creating agents of the lawyer. And in another way, you're extending the privilege because you're creating agents of the client. And that's a nice sort of dichotomy to think through this. On the agents of the lawyer side, there was a roughly 1960 criminal tax case called United States v. Cavell or Cobble. And in that case, a judge looked at a situation and decided that it makes sense sometimes for third parties to be in the room when attorneys and clients are having conversations. The judge analogized that to the presence of an interpreter. And actually, interestingly, yesterday I was driving home and I heard on the news that Congress is considering subpoenaing the notes from interpreters with presidential discussions with other foreign leaders. So sort of interesting coincidence. But back to the law. Under the Cavell doctrine, courts have said, okay, you can have a third person with you that's not your client when you're talking with your client if that third person plays a vital role. And that role is helping you translate what it is that the client is explaining to you, or helping you understand what the technical issues are at hand in the investigation. And so that's like an interpreter. So you're always on safest ground when you're using a third party in your investigations, and they are doing that. They are investigating something on you and explaining it to you. Where you start to get attenuated is when you have third parties that are not interpreting something for you, not helping you understand technical data. And there's another court case out there called Equate, where the judge said, okay, we're getting a little too far from the Cavell doctrine and put the stop to it. And that is that you're not acting as a translator or interpreter for client information. I think we had a question, so I'm going to look at that and see if I can answer that. Okay, so Jason, we have a question. Can you just cover one more time the distinction about congressional hearings and why the privileges don't apply in that setting?
Sure. The creation of these protections are judicial doctrines, as Kevin was sort of outlining from the Cavell decision and Equate. The courts are the ones who have explored attorney-client privilege and the protections of work product for purposes of having a trial in the context of a judicial body. But in a congressional investigation, those judicial doctrines do not apply. There is no statute of the United States that establishes an attorney-client privilege or a work product doctrine. And so going into a congressional investigation, cannot assert an expectation of protection to communications with your lawyer.
Okay.
There are practical ways that Congress has, in most instances, respected attorney-client communications when it wants to, but you do not have sort of the precedent of judicial decisions to rely upon for those protections.
So if you want to protect information in that context, one thing you could do is look at your constitutional bases. Some of those might apply in that context and help you prevent testimony if the facts warrant. So we're going to go back to Cavell, and we're going to look at that doctrine in context. On your screen, there's some green and there's some red. Green is where it worked, and red is where it didn't. One big case that it worked in was the Martha Stewart criminal case. And, even from my perspective, I think this is a little bit of a stretch and surprising. It's very interesting facts, but, Martha Stewart was subject to indictment at the time. It was very well known. And the law firm that was representing her with the government was trying to get the government to not indict her. And so the law firm engaged a public relations firm to literally shape public opinion and counterbalance what was being said in the press. So they developed a strategy to make, nice things said about Martha Stewart in public. And the idea was they'd convince the members of the grand jury to not indict her. Well, that didn't work, obviously. But there were communications between the law firm and the PR firm that the government was very interested in, and they pushed for those communications. And a judge said, you know what? This PR firm was really acting as an agent of the lawyer. They had legal goals, and the PR firm was instrumental in achieving those goals. And on this set of facts, with this high-profile defendant, I'm going to let the privilege stand, which was surprising, but it worked in that setting. It's a limited case. I don't think, from precedential value, it'd be difficult to stand on Martha Stewart, but it did work in that context. Something a little closer to home for this audience is a Chipotle case that really dealt with the idea of specialized knowledge. And so, remember when we were talking about Cavell, you go out and you get your third-party consultant to help you understand something. And so in the Chipotle case, the court said, well, what exactly is it that this third party is understanding on behalf of the lawyers? Can the lawyers not do this? And the third party was a HR professional who was looking at job function analyses and interpreting that for the lawyers and having communications with the lawyers. And the judge didn't think that was strong enough. They didn't think that, the ability to look at an HR information was, warranted specialized protection. And so what that case stands for is the specialized knowledge has to be something beyond your ability as a lawyer, as in-house counsel working with your client to understand the information and then render legal advice to your client. And then in the Chevron case, it's another case that went the wrong way from this doctrine's perspective. Legal was discussing the structure of a deal, and they were communicating with folks at Price Waterhouse to help them best understand the deal. And so Price Waterhouse does what Price Waterhouse does. They came in, they made a presentation, they helped educate the legal team on some of the nuances of the structure that was being put together. And the judge said, yeah, that's not good enough, right? That's getting away from the idea of translating something, translating English to Spanish or translating accounting principles in Cavell to something that a lawyer could understand. This sort of basic accounting 101 was not sufficient. And so the court distinguished between, the ability to a third party to assist with the lawyers providing legal advice and just simply understanding a financial transaction. I think that's tough in the EHS context because it's such a broad field. You have environment, you have health, you have safety. Some of you on the phone probably have a responsibility for security, particularly cybersecurity. And I can envision a situation in which, you're going to have third parties that are going to come in and help you and help your client. And part of that function and role is going to be to educate you on an area that you're not as familiar with. And so those are where the fault lines are. It's important to know that there are cases that cut against that, but I think you can make the argument. As long as you're tying the information you're receiving and the role of the third party to helping you render legal advice and translating and better understanding information, I think those are the keys. So in practical terms, particularly in the context of your incident investigations, in this presentation, we wanted to give you some language that you could use in some areas to look for, to include language in your consultants. And, all of you, this is a very sophisticated audience. You all have robust safety programs and pretty well thought out protocols for how you investigate incidents. For example, I was just on the phone last week with a company that, like many companies, has a 4-tier system, a 4-category system of how they sort of evaluate the incidents that occur at your assets, your plants. And, they had a level 3 out of 4 incident that warranted an internal investigation using a third-party subject matter expert to help assist the company, because the investigation from safety's perspective was serious enough. But as usually is the case, the legal team was about 3 or 4 days behind the business unit team, because the business unit team had already gone out and found themselves their third-party subject matter expert and already exchanged emails with them and telephone calls with them, and so they had already built a record of information before legal really got involved. Of course, once the general counsel saw what was happening, he wanted assistance, and so we stepped in to try to help him. But as soon as you're aware of what's going on and you realize that you're going to use a third-party consultant, you need to send them an engagement letter, and it needs to come either from the legal department or from your outside law firm that you're using to assist you. And it needs to be the lawyers who are engaging the third-party consultant. And I've given you an example of, to the extent there's ever magic words, this is pretty good in terms of, having something in a simple letter that makes it clear that, the legal department is engaging this consultant for legal assistance, and specifically translating technical data or whatever it is that you need them to do so that you can better render legal advice to the company. And then the consultant always is going to have their agreement, and they're going to have a statement of work attached to their master service agreement. And it would be helpful if you could talk to the consultant and say, look, you need language in your SOW, your statement of work, that mirrors what we're putting in our engagement letter, so that it is clear from these 2 pieces of paper that the legal team engaged you, the legal team is overseeing you, and you're assisting the legal team in providing its legal advice, and we want you to keep this confidential. And so the right side of this slide gives you some language as a starting point to make sure that your consultants have it in their documents as well. And then when you're in front of a judge, it's just a complete story, and you don't have a outlier statement of work that cuts against what you were trying to do with your Cavell letter or your engagement letter. So we go ahead, Jason. Did you have something there?
Well, let me just interject a couple of things at least from a transactions and enforcement perspective. So, the sequence that you laid out obviously is the ideal sequence, right, where the law department or its outside counsel engage the third-party provider. But sometimes that doesn't always happen in the sequence that we would desire. You can try to sort of paper that in hindsight with a supplemental letter that refers to the initial engagement and indicates, with some of Kevin's magic language, why the consultant is being engaged. If I have the opportunity to sort of layer in some additional language, I like to have additional language in the engagement letter that directs the consultant to label all of the work product that they produce as privileged and confidential, prepared at the request of counsel, so that 1, they'll do it, and 2, if they fail to do it, that I can refer back to the engagement letter where we created that expectation. In the transactions context, when you're doing phase 1 or phase 2 reports, or you're or part of due diligence, I think number 1, you can start from the expectation that you will attach privilege to the materials, but 2, you ought to be cognizant of the fact that often those reports take on a life of their own down the road, and so you need to draft the materials with the expectation that maybe the privilege won't continue to attach down the road. So watch out for things like recommendations in the reports. You may want those to actually be provided to you separately, particularly if they're in writing. If you're representing a buyer, a recommendation or the identification of an issue imputes that knowledge onto you as a buyer, and so you have a finite period of time post-closing to deal with that issue. And also bear in mind that oftentimes the reports that are prepared for the company by a consultant in the context of an acquisition are provided to a prospective purchaser in the context of a divestiture. And so that report will have a different life years down the road. And so you want to anticipate that when you're putting together the final language and draft it accordingly. Likewise, if there's financing associated with the transaction, in most instances, the banks require you to provide to them or to their consultants copies of the final reports or final drafts of the reports. And once that happens, the argument to attach privilege is at least arguably vitiated, and that makes it more difficult if a desire for that document is challenged in a court of law or somewhere else. So just some practical considerations as you think through the role of outside consultants and how to paper that relationship as you enter into it and as you create documentation related to their findings.
All right, thanks, Jason. We're going to pick up the pace just a touch so we can get through some more of the material this morning. But we started when we talked about these two areas. One was extending the privilege with the concept of agents of the lawyer. Now we're going to look at agents of the client. This is my own shorthand. Courts are not using the phrase agents of the lawyer and agents of the client, but I think from an instructional perspective it helps. So this also protects communications when other people are in the room, but the other people in the room this time are people who are doing the functional equivalent of what an employee for your client would be doing. It's just your client doesn't have those kinds of employees for whatever reason. The classic energy-related one is landmen, and we'll see that case in a minute. But most upstream companies really can't do their job without landmen, and so landmen are in a lot of communications, and courts time and time again have said that's absolutely fine. Where it gets a little trickier is with PR firms, and we already saw the Martha Stewart case in a court allowing a PR firm communications to be protected, but the court cases go both directions, and we'll see a summary in a moment. But there are 5 factors up on this screen. You don't have to have all 5 factors to establish the functional employee equivalent, but you need to have some of the factors. And so the more factors you can have, obviously, the better. But it's that close and continuing working relationship between the non-employee and your company. And a lot of times, if they're the sole source of information that you're relying upon, those can be extraordinarily good facts. So here's just a quick overview. Again, green is good, red is bad. A lot of the analysis that courts do, they overlap the analysis. Sometimes they do functional employee equivalent when they should have been doing Cavell and vice versa. So you'll see some cases pop up again and again. But the Sumitomo case was probably the best example because it was a foreign company who really didn't have a PR team in the U.S. and they were getting pounded by the media due to some incidents they were having. What's interesting when you think about the Martha Stewart case and you contrast it with the Hunan case, which was there the legal team thought, okay, well, we're going to shape social media because we want to induce settlement in the other side in the plaintiffs, and the judge didn't like that. And you sit there and you say, well, on the one hand, they allow shaping social media to avoid indictment, but they're not allowing social media. They're not allowing a PR firm to shape social media to induce settlement in a civil case. It's just an interesting juxtaposition. But there are arguments on both sides. I think we can go past this Busarma Excella Health case study just for time purposes. But in this instance, outside counsel wrote an opinion letter, and then the defendant retained a PR firm to advise it on public statements about physicians, and so you had legal engaging PR to sort of help it deal with a problem, and legal sent PR some analysis. And so then the question was, can that analysis be protected? Can it still be considered attorney-client privilege? Was the PR firm serving as a functional employee, or were they just doing the PR job, the normal PR job? And in that case, the court cut the other direction and didn't protect the information. So that sort of ends the part of the presentation about the extension of privilege as you deal with either people that are helping the lawyers, particularly in the context of an internal investigation or a deal like Jason was describing, or people that are affecting your client, which are your functional employee equivalents, and sort of how the case is cut in both directions and some Cavell language to help you engage your clients. We're gonna change topics slightly, but we're still in the same general area, and that's just protecting your communications as lawyers who often wear more than one hat in the organization. Courts realize and recognize that, and different jurisdictions treat that differently. But there's a couple of tests that have popped up. One is, what's the primary purpose of your communication when are you functioning as general counsel, deputy, or associate general counsel, or are you functioning as VP of compliance, for example? And so courts will look at what the primary purpose of the communication is when you issue that communication. Some courts will look at all the things that are discussed, like the Vioxx case did in the Fifth Circuit, and see if the legal advice and the non-legal advice are so inextricably intertwined that we just have to protect those communications. But from a practical perspective, just being mindful of the fact that down the road, someone's going to look at your communications in a cold, objective way and try to decide, were you functioning as a lawyer, or were you functioning as a business unit leader or offering business advice? And so those pop up quite a bit. And we've talked about these before at the seminar and in telephone calls with some of you, but here are some common examples from the environmental world. Jason, do you have others that you want to add to this list?
No, but I think the thing that I would just highlight is, you said, are you functioning as a lawyer or giving business advice? And I think probably a number of people on the phone also function both as a lawyer and as an EHS function. And the question will be, many of your in-house clients CC you on emails with an expectation that doing so has protected the communication. And so that both requires an analysis of whether or not you are functioning as a lawyer for purposes of having been copied on that communication, and the Covell and Ackert sort of decisions that Kevin outlined at the beginning. But I think merely copying an in-house lawyer on a communication does not establish the privilege. The court will dig, if pressed, the court will dig much deeper into the underlying facts and the expectations of the parties in the communication to determine whether or not the privilege attaches.
No, that's absolutely right, and that's the topics of a little bit of theirs on the last bullet to this slide. There's just some things that are technically not privileged, and it's always tough. But if there's a regulation that requires you to conduct an investigation and then make a report to the government about that incident, or make a report about the incident, the one that has to be initiated within 48 hours and include at least one person with subject matter expertise, you're not going to be able to protect that under the work product doctrine, because there's a regulation that requires you to do it. Nothing prevents you from creating a shadow team to do the same investigation with a broader mandate. You can certainly protect that if they're providing legal advice and helping you get ready for either government enforcement or a plaintiff or worker injury claim. But the one that you have to do for the regulation is not privileged, and you got to help the business unit understand that. And like Jason said, just CCing you is not sufficient. And I think, now's a good point to sort of just interject some practical thoughts about it. Investigative agents don't understand privilege either. They don't understand work product either. And so a lot of times you can make a good faith argument that you think something should be privileged or something should be work product, and that may be sufficient. And if you produce your log and sort of push back with the government inquiry or some plaintiff inquiry, you may be okay. But in our experience, and personal experience, and also in the courts, most of the time companies overassert their doctrines or their privileges. And when push comes to shove and you're really standing in front of a judge and he or she is reviewing that information in their chambers, most of the time the companies have to produce some of the material that they thought they could withhold. And so the idea is just to be aware of it, do your best to do some things to give you the best argument down the road. But realize that most of the time you're not going to get pushed that far, I guess is my point. But when you do, we got to be prepared. Jason, any final thoughts?
No, I think this is good coverage in obviously a 30-minute webinar. This is a topic that has a lot of depth and a lot of different scenarios. I know there were a couple of questions submitted that we didn't get a chance to get to, and others may have questions that they're hesitant to ask in a public forum. But please do feel free to call us or email us if you have questions on this. It's an area of law that Kevin and I have spent a lot of time in. We appreciate you joining us again this month for the webinar. If you have suggestions about topics that you'd like to hear about that are sort of more practical in nature, like this one, or sort of a Washington perspective on any of the issues that are happening from a policy or regulatory perspective, we're happy to provide those. This presentation will be put up on our website on the Insights tab, the Bracewell site. And thank you again for joining us this month.